Hello, this is UncleYap, and we have a case of injustice suffered by senior citizen. This is Mdm So. She doesn't speak Mandarin or English, and I will add subtitle while I interview her in Cantonese. Auntie So 你好。
我身體都唔好咯，因為呢件事呢件案啊，拖咗我幾年，精神上啊、身體上同埋都傷晒啦。
你今年幾歲啊
？80啦。
哦，80歲啦。呢件案係開始係2000幾年。
唔知2007啊。8啊，2007、
2008咁啊。
嗰個時候起㗎啦。
哦，咁啊已經上咗庭
幾次啦。
幾次喎？
咁咧因為對方講大話，我係10萬嘅本錢，咁講大話又話我20萬。
喺法庭講大話。
喺法庭嗰度，我話我10萬，收尾法官又話我20萬，咁對方個律師黃兆平又話唔係我嘅錢，咁收尾法官又判啲錢唔係我嘅，要割俾阿謝國晶，咁我哋變咗拖咗幾年，我冇收入啦。
謝國基就係你個仔。
我個仔。咁我幾年冇收入，而家我又病痛多，又要生活費，又要醫藥費，乜嘢都冇，連我棺材本都冇埋。
呢筆錢係你養老金嚟嘅。
係我養老啊，因為我仲一個丈夫中咗風㗎嘛。
咁佢都又係
有醫藥費㗎嘛，要生活費㗎嘛，將來亦都係要生活棺材本㗎嘛，乜嘢都冇晒，搞到我哋。
所以法官冇同你搞清楚，你係希望法庭將你判清楚佢。
我而家希望我法官判分清楚佢啦，係咪？因為佢講我20萬，我又唔係20萬啦，我係10萬啦。4萬就係資本嘛，6萬呢就係借俾公司㗎嘛。我2張貼嘛，有朋友對嘛，點會唔係我㗎錢？呢啲錢的確係我嘅，我都要按錢嘅咯，我哋係養老㗎嘛。而家呢幾年搞到我乜都冇㗎。
所以阿啲而家呢個案，你覺得有冤，即係造成你心情受影響，你休息唔好嘅話，瞓唔着，
夜晚瞓唔着，
健康受影響，
受影響咗。
而家你係腰脊骨問題，
腰脊骨腳你都傷㗎啦。
眼問題，
眼嘅問題，
又精神上壓力休息瞓唔到
啦咁幾年咩唔傷啊？一個老人我哋點可以頂咁耐？
其實呢啲錢人哋愛養老愛睇病咁冇嘅時候覺得呢啲咁嘅壓力，就老人家健康更加受得住。
食又唔安樂，瞓又唔着，係咪？
咁你係希望而家法庭幫你公正？
公正翻啦，
搞清楚呢件事，攞翻你啲老本。
攞翻我個老本啊！
明白。咁呢啲詳細嘅嘢我就問你個仔，因為佢講英文。
呢啲係我自己係清楚呢啲啊，其他要問我個仔我唔記得咗㗎啦，咁耐。呢個本錢我一定記得㗎嘛，係我血汗錢嚟㗎嘛， 點可以話唔係我，唔係我，咁就唔係我㗎，係咪？
官冇同你搞清楚，唔根據個證據文件嚟。
係。
而家我訪問你個仔，你接住用英文問答。
好。
So I will commence interview with Mdm So's son, Mr. KK Chia, in English. Mr. Chia. Mdm So's back is suffering some fracture, so she cannot sit down for too long. She needs to be in a non-sitting position. She cannot, her back will be very stressed in the sitting position when she sits for too long, she cannot take it. Hi, Mr. Chia.
Good afternoon, Mr. Yap.
Good afternoon. We will conduct your portion of interview in English. So that was your mom, Mdm So, and briefly, in like 1 minute span, you just say about your case involving in investment and Singapore.
In 1996, I found a hydropower project in Dujiangyan, Sichuan province, China. And after 9 months of feasibility study, found that it was viable. And so my parents introduced the partner, Tanwa, to invest in the project together with my mother and me. And I managed the project from 1996 till she stopped the payment of dividend to us, instructing the Chinese not to pay. When I had this discovered that my invested capital was left out of the account.
So you have some. Okay, I just suggest that you sit, not lean too much to the back, that your chin become up, and it doesn't look very good. You have suffered grievances in this case throughout the hearing. Is that correct?
Yes.
And your mother is very stressed, and the stress affected her health. Can you briefly introduce this?
Okay. My mother suffered compressed fracture of the backbone.
Compression fracture.
Yeah, compression fracture of the backbone in L4 and L5 shortly after the judgment was announced. And after that, she suffered now the loss of vision, partially because of some age-related degeneration in the vision. Recently, she had hemorrhage in her left eye and is still under treatment.
So she needs to pay a lot of medical expenses.
Yes, we've been selling things to pay for all this.
Selling the assets?
Yes, because our rightful dividend have been withheld by my partner, Tanwa. And after the court pronounced a judgment, she enforced the floor judgment.
And she mentioned that your dad also suffers stroke, needs medical expenses.
Yes, my dad had a heart bypass operation quite long ago, about 20 years ago. 2002, he suffered a stroke, and shortly after he had what you call dementia. And now he's under constant medication, and he's also wheelchair bound. And I have to take care of both of them. It's a lot of stress.
So that's why you sue for the money.
I sue for the amount that I invested but left out of the company account from day one. I did not discover it until many years later, because after we remitted our money, I was firefighting, trying to salvage, to get the Chinese to enforce the contract, and I only managed to get everything under control in 2002, and that's when I had time to go through the company documents, and I discovered that my money was omitted out of the capitalization of the company's capital. I informed my partner. She said she would rectify it, but she failed to do so. And when the thing dragged on for 2 years, I asked lawyers to write to her, requesting her to do something about my investment. And instead of doing something, she actually got the Chinese to withhold paying dividend to us, draining my resources.
I see, that's what you do. So how do you feel about Singapore's High Court handling your case? Your mom expressed a lot of dissatisfaction.
I will go to the latest incident.
Yes.
That is very surprising to us.
Yes.
We had a hearing called OS 331, and in the hearing, at the end of the hearing, there was no cost awarded.
From beginning to the end?
Yeah, from beginning to the end, there was no cost awarded. But subsequently, my partner's lawyer, Mr. S.P. Wong, demanded cost.
That means throughout the transpiring of the case, they did not apply for you to pay their cost, and no discussion transpired, and no ruling was made by the judge. But after the case over, they start to insist that there was some cost awarded to them. Is that correct?
I will add to it. From my limited experience, usually in appeal hearing and other hearing at the Court of Appeal, at the end of the hearing, if one side won and one side lost, the Court of Appeal judges would ask the winning party how much cost they demand, and they will ask the losing party if the amount quoted is agreeable, and if there is no objection, that will be the cost awarded. I have personally seen that in a few hearing cases.
I have my own experience as well. That usually it will be two-stage. First, there will be a decision to come, and one side who win the case also ask for the cost, and if the judge is agreeable to this cost, he will still ask the opposite side, what do you think? You can start to then argue that there shouldn't be cost. Then your argument will be heard, and back and forth, the judge will then finally decide whether there is or is not cost. And whether there is cost awarded or not cost awarded, it should be part of the judgment, the recorded judgment. And the transcript should have recorded all the argument, whether once I had initiated to apply for the cost or not. In your case, you insist that no application was even made. Nothing was said. Nothing was ruled. Correct?
Yes.
Then there will be a second part of this to determine how much is the cost, which is the law call it the taxation process, which can be a separate hearing if it's lengthy. Then they will say how much time they have spent, how much was incurred. Then you can say, oh, because for certain reason this is your own fault, this should not be counted, that is okay, this is not okay, then fix the amount. The judge will fix the amount.
For that first part that you mentioned, none of those activity happened. The Court of Appeal judges just dismissed the case and they went into the chamber. They did not ask Mr. S.P. Wong if he wanted cost, and obviously they did not ask my solicitor if it is agreeable. And there were members of the public who were present
Hearing the trial.
yeah, during the hearing of the OS 331, and they have written statutory declaration that there was no cost awarded at the end of
Make
the trial.
statutory
Yeah, they have
declaration.
made statutory declaration. So when Mr. S.P. Wong demanded cost for OS 331 and also demanded cost for an earlier appeal, which also no cost was awarded, the lawyer representing me actually wrote to the court for clarification on the matter. Unfortunately, after four attempts, we did not get a reply on requesting for the recording of the hearing and also to clarify the matter.
I just make this a bit clearer. This is called transcript of the trial. The lawyers sought to obtain the audio recording and transcript of the entire trial. Two separate trials, the costs were in doubt, whether there is or no cost awarded, to sort out whether during the trial was there any ruling of cost. But the court, what did the court do about that your attempt to sort transcripts?
They give a few written reply, and the final reply, the third reply, said that it's final, and they agreed with Mr. S.P. Wong that there was cost awarded, and they ignore our request for the transcript and the recording.
So you failed to obtain the transcript, because
Yes.
the transcript is a public record, a formal record of what transpired in the whole trial. That if there were any subsequent disagreement on what actually transpired, this will be the solid record that anyone will rely on, even the media can apply for transcript to understand actually what transpired in the trial. And they refuse, is it? They refuse and ignore your request.
They ignore it altogether.
And then the reply to you is that there is cost
Yes.
that was indeed awarded during the Court of Appeal and one other trial.
Yes.
Isn't it quite surprising and shocking?
Yes, very surprising and shocking that it happened in the Supreme Court of Singapore.
Yes, because these are open court hearing, and the hearing is supposed to be transparent and fair and make clear to the public, and no secret dealing behind the back. And anything has been brought up, discussed, argued, and the judge, based on hearing the argument, decide and rule. And the whole process is recorded in transcript. That the transcript are public record, the media can get in, any member of public can get hold of the transcript. The media can report based on the transcript. This is the reliable form of evidence that what happened in a transparent and fair trial. But the transcripts become inaccessible to the public, vanish, and even the party in the trial that has doubt and disagreement arise from what actually transpired, try to obtain this public record. It's been denied. So this is how Mr. Chia feels, that he suffered injustice, has been wrongly treated. That's why he has this Chinese word, yuan, this injustice on this banner he made. Mr. Chia, tell us about your activity in how many part with this banner?
After the taxation for the case 558,
which is earlier number, right?
The opponent's lawyer, Mr. S.P. Wong, demanded cost of 1.22 million.
Is it cost or that 1.22 is just cost? It's not anything else.
Just cost.
That means his legal fees.
Yes, his legal fees and I think his disbursement. 1.22 million, and he claimed it on the basis of the fact that earlier the judges had asked him to split the case into 3 cases, and upon checking this and having written to him to provide the evidence that the judge asked him to split the case into 3 cases, which he refused, and I went to the registrar to extract a copy of the in-chamber hearing. It not only proved that the judge did not ask him to split the case into 3 cases, instead we found that he was lying to the judge to obtain success in his appeal against, strike out against his case.
That means he made, I'm assuming, he made some misleading submission to mislead the court.
Yes.
I see.
It's not one-off. There's many misleading statements and lies, and some of it are documented, and these are the documents that I have used for my new writ of summons.
I'm a bit confused in this aspect that if your position is that there was indeed no cost awarded in your cases, you should have refused to attend the taxation, because the taxation means a process to discuss the amount of the cost.
Okay.
Did you reject to
let me clarify
or
this.
did you have an opportunity to sort it out before you attend the taxation?
Okay, let me explain this. There was cost awarded for 558. There was no cost awarded for 127. I was representing myself in the taxation because the lawyers...
You have 3 case numbers so far, right?
Yes.
558 and 127 and 331. I see. So in 558 there was cost awarded.
Yes.
In the other 2 there was none.
Yes.
So you attended taxation for the one that...
I attended taxation when Mr. S.P. Wong sought cost for 558
yes.
and 127. As a layperson representing myself then, I did not realize that since no cost was awarded in 127, I should not have entertained him for taxation for 127.
That means you should have applied for the taxation limit to 558 only, and since there's an argument whether cost was or not awarded in 127.
Yes.
So there was a mistake on your side that you didn't insist this.
I did not know that when there was no cost awarded, then there should be no taxation for that process.
Taxation, if you attend a taxation process, become something beholden to yourself, they're going to say that you agreed to it eventually, you know.
Yes.
So it was a mistake.
Yes. I didn't realize that until the lawyer who represented me for case OS 331 told me that when there was no cost awarded at the end of the hearing, then you need not pay cost.
Correct.
And after knowing that, I went to the Court of Appeal to hear a few Court of Appeal cases and realized what would actually happen if cost was awarded. And it was very
you attended other people's cases.
Other people's cases. And then it occurred to me that in my case of the appeal hearing, there was no cost awarded, and I had transcript of the appeal hearing provided to me by my appeal lawyers then, and it clearly indicated there was no cost awarded at the end of the hearing.
So what did the court do at the taxation? They drew one lump sum for 558 plus 127, or is it the two separate sums?
Two separate sums.
So that means you will, in your position now, you will agree that at least 1,558 cost that stamp and 127 should be voided.
I objected to all the costs because my opponents obtained a favorable judgment based on lies, misleading the court, and that is the issue for my present case, S97.
I see. So you still have argument about that, but at least the big surprise to you is that something that was not ruled by the court, that any cost that you are liable to pay, after it was over, suddenly they say there is cost, and what actually transpired in the hearing, you try to prove it, they deny you access of the transcript.
Yes.
I have several personal experience myself in cases that transcript was supposed to be easily obtained. Initially, I only paid $6 to the electronic digital transcript department of the High Court. They give me CD or DVD recording all the audio, every word said by the judge, every side of the trial, witness, and so on. It's recorded, and I can buy the whole thing recorded digital form for $6. And ever since, after election 2006, defamation suit, Lee Kuan Yew and Lee Hsien Loong versus Chee Soon-juan, Chee Seok-chin, and SDP. It went on. What happened was the digital recording in the court, when Lee Kuan Yew was a witness cross-examined by Chee Soon-juan, was obtained by either Dr. Chee or SDP and put on the internet to embarrass Lee Kuan Yew. They start to obstruct and scrutinize all the... It became very difficult after that for us to obtain any digital recording of any trial. So your trial in 2007 was approximately starting that time. Ever since then, the court have been denying most, if not all, of my application to obtain the recording in the court. That the attitude is they will not approve. When I asked the judge to approve it, the judge said, decide later. He shunned from making this decision, and later on, just no recording will come to me. And then in one case that I was very firm to try to obtain, they compromised a little bit later to say that, okay, this translated transcript, typewritten transcript in the form of a bonded paper, so the cost was actually $200. They said they give it to us for free, as long as you don't ask for the audio recording. So unless I scan these papers, I can't prove the case on the evidence on the internet. That's what they are afraid of. They don't want the evidence in the court, that sensitive content, to be exposed to the internet. They try to deprive the public from the knowledge of what happened in the open trial, which is supposed to be fair, open, transparent. This is something that I share, that adds on the light on what happened to Mr. Chia's case. So Mr. Chia, are you still pursuing your cases?
Yes, of course. There's injustice, and I will pursue it right to the end.
Yes, you according to my understanding, that you are quite insatisfied to not just the part of whether there's not a cost, but the frauds by your partner, and So your company secretary changing documents of the company behind your back. The court ignore it so far.
To be fair to the court, those things were issues in the correspondence between my lawyers and their lawyer. However, they refused to answer to pointed questions raised by my lawyer. And in the trial, it strangely become non-issues. And the judgment, because of the lack of the facts and the misleading statements that were presented in the re-amended defense and counterclaim, actually the judgment was affected and is flawed.
Because the matter is long and complicated, I will break your case in several different interviews. In this episode, we just highlight that something that transpires in a hearing without cause can, out of the blue, out of nowhere, prop up to have cause. And when one side tried to obtain the transcript and recording to prove there was no cause, it was denied. And this is something that we'd like to highlight. And the other parts, I will subsequently arrange 2 or 3 separate interviews with Mr. Chia to introduce what's going on, because this is public interest that the courts process and protects everyone's rights under the law and fairness, and that we entrust the judiciary to uphold justice for us, whether civil or criminal matter. It become very doubtful and very dubious, and give people no faith of public interest, of equality, fairness, and rule of law. So if there are these flaws, I would very much like to highlight them using the internet media and bring attention to the members of the public. And I hope the officers concerned will get this message and give them a chance to correct whatever negligence or mistakes they might have made. So we arrange another video recording with you in about a week's time.
Sure. May I add on a little bit just to clarify? In case 558,
yes,
I actually paid for the digital transcript service, and I have CDs and recording for 558.
When was the date of that?
That happened in 2007. February 2007. And from 127 onward and 331, I could not obtain transcript.
If you check the dates, February 2007 was before Lee Kuan Yew's defamation suit. This thing happened after. The date will be very interesting. Anything else, Mr. Chia?
That's all I can remember of that now.
Okay, thank you, Mr. Chia, and thank you, Mdm So, and I will conduct another continuation following up. Thank you.
Thank you, Mr. Yap.